Hi, Attorney Kip from Malek and Malek, and as always, with this workers' comp stuff, I highly recommend you talk to a workers' comp attorney. You can either reach out to us, Malek and Malek, or there's a lot of great workers' comp attorneys in and around Ohio and Columbus, Ohio, for instance, and the whole state. Anybody who operates in this area, if just they'll know what they're talking about. Otherwise, ask your friends for referrals. Look on Google, and then find somebody that you like to work with, and go with that. But today, with that suggestion, or it's not even a suggestion, it's almost a command. Um, I'm going to talk about basically, and this is kind of following along on another video that I did about the 412390 workers' comp retaliation statute. Um, the bottom line is workers' comp claims, when you have there's two universes. There's the workers' comp universe and there's employment law universe. And workers' comp, it doesn't protect your job or your position forever. So you have a workers' comp claim. One of these, a common thing that people come to us, they're like, I have a workers' comp claim and they terminated me, and how can they do that? Because I got injured on their job, and that's not fair. And the bottom line is, although I don't disagree that I do believe that it's not fair, but the bottom line is the employers do not have to employ you forever. So if you're injured and you can't do the essential functions of the job, um, you know, you, they don't have to keep on employing you. Okay, um, and so with some places, like if you work for a place that has a union, like some of these state employers, they'll have unions. They'll have procedures where you could take injury leave, or an injury leave will protect your position for X number of weeks or months. Um, some like employers like an Amazon or a Cardinal Health and these other things, they have injury leave processes that you can get involved with, and they'll, once you apply for that and it's granted, then they'll protect your job for a certain amount of time. But bottom line is, you have to take this affirmative action. You can't just assume the employer is going to hold that job forever. Okay, so, and at the very minimum, if the employer doesn't provide that, then you might be able to apply for something called Family and Medical Leave Act relief, or FMLA relief. Um, so, but the caveat with FMLA relief is you have to be eligible, okay? And so you have to meet all three of these following requirements to get FMLA relief. And so, and also, FMLA, if it's granted for you, it only protects your job for 12 weeks. So basically, 3 months your position is protected. After those 3 months, if you're after work, you might be able to reapply for further FMLA, but at the bottom line is that's the minimum. And if once that 12 weeks is exceeded, then the employer can, again, they can let you go. They could terminate you for a non-discriminatory reason. Okay, so if you can't do the essential functions of the job, then they could say, hey, we can't keep on employing you. Okay, so to be eligible for FMLA relief, you have to have worked for the employer for at least 12 months. So that's number one. Number two, you have to have at least 1,250 hours of service in 12 months before taking the leave. Okay, and then the third thing is you worked at a location where the employer has at least 50 employees within 75 miles of the employee's work site. So if you work for an employer and they have less than 50 employees, so that's your smaller employers, you're not going to be able to apply for FMLA. Okay, and so how do you apply for FMLA? There's forms. If you search for, I'll actually put a link in the video, but there's a form that the FMLA government site provides. You have to give that to your doctor, and um, they complete it. And basically, what this form asks is, what's the medical condition necessitating a leave, whether or not the employee is able to or will be able to perform the essential functions of the job, and then the amount of leave needed. So do you need 2 weeks, a month, or again up to 3 months. So a medical provider has to fill this out. You give it to the employer. If you're eligible, they'll grant your FMLA leave, and then your job position is protected for 3 months. So that's workers. That's what's going to protect your job. But bottom line is, and this is something that this comes up all the time. Sometimes employees, they get injured and they think like, oh, I have a workers' comp claim. My employer knows what's going on, and my employer is going to look out for my best interest. I'm just telling you, your employer is probably not going to be looking out for the best interest, and your employer is probably going to be focusing on how they can limit their financial exposure to the fact that you're injured, and that they're going to have to work around your injury and all these things. So they're not going to be looking out for you. You got to always be looking out for yourself. Okay, so that's FMLA. If this comes up, talk to your attorney, bring it up, let them get some advice from them. If you're impinging upon an employment law issue, they might refer it out to an employment law attorney, because workers' comp and employment law, they look similar, but they're two totally different universes. Okay, so you've been listening to Kip Malek, and as always, leave questions, comments in below, or email me at my email, and then I'll try to answer them if I can. Otherwise, if you have a workers' comp claim and you want to talk to one of us, call us up and we'll talk to you. But be that as it may, thanks for watching the video.